May it please the court. My name is Bob Rehkemper. I have the privilege of representing my friend Dave Hellstern in connection with this appeal. This appeal comes to this court based upon two simple, straightforward, and reasonable requests made by Mr. Hellstern after he was placed under arrest, taken to a law enforcement center, and asked to submit to chemical testing. His question was simply to the officer, "Can I have a moment with my attorney?" The officer responded, "No, you can, but not on the phone." Minutes later, Mr. Hellstern then followed up, "Can I have attorney-client privilege?" The officer responded, "Not on the phone." Mr. Hellstern was never given an opportunity for a privileged and confidential consultation with his attorney he was speaking to. This violated two particular principles that we put forth in our brief, Iowa Code Section 80420, and in my opinion, more importantly, Article 1, Section 10 of the Iowa Constitution. Since it is Constitution Day, I'll address the constitutional issue first. I think it is much more of an interesting debate and discussion as well. Article 1, Section 10 of the Iowa Constitution is special. It is different and distinct from any other provision that mimics the Sixth Amendment under the Bill of Rights in any state out there in the Union. It has very special language that was not accidentally put there. It was intentionally put there and requires that it be applied in a broader manner than it is or otherwise would be under the Sixth Amendment to the United States Constitution. If Mr. Hellstern had the constitutional right to consult with counsel, he similarly would have had the constitutional right to consult confidentially with counsel. The fighting argument under the constitutional argument is whether or not Article 1, Section 10 can be deemed to have attached prior to the filing of the formal charging documents in the criminal prosecution. When you look at the case law, you look at the literature, you look at the articles that surround this topic, there's really two approaches. One is the mechanistic approach that is followed under the Sixth Amendment Bill of Rights under the federal courts, which is if the indictment is not filed, Article 1, or in that case, Sixth Amendment right to counsel does not attach. The converse to that is what I would refer to more as a substantive analysis, where we look at the purpose and the role that counsel would play in that particular proceeding and determine whether or not an individual who has been arrested, who is accused, would stand to lose something or be put at a disadvantage by not making counsel available to him at that point in time.
Let me ask a question about the... Oh, go ahead.
Thanks. Don't we start with the text of the Constitution, and the Iowa provision refers to, it begins with in all criminal prosecutions, and we don't have a prosecution yet when they're out on the side of the road. And it continues with, and in cases involving, et cetera, et cetera. Well, there's no case until there's something filed, right?
There's a case the minute an officer decides to place somebody under arrest, would be our interpretation. There is a case involving life or liberty interest at the time implied consent is invoked at the station. We are arguing this in the context of an operating while intoxicated case, because operating while intoxicated cases, as a result of implied consent, are different than any other type of criminal prosecution.
If the officer left the room, would the Constitution be, constitutional violation exist?
In this case?
Yes.
Yes, because they're still recording, they're audio recording and video recording the conversation between Mr. Hellstern and his attorney. In fact, it did happen in this case where he left, but for a minute or two, we can see and we can hear the conversation, portions of it, that Mr. Hellstern is trying to have with his attorney at that time.
Both sides of the conversation or just one side?
Just one side. But as we know, one side of the conversation is all they need to hear for attorney-client privilege to be waived. And that's one of the struggles with this and with this general conduct.
The recording one side of the conversation, does it even pass muster under 80420?
It does not. And we've also argued under 80420 that the officer knew what Mr. Hellstern was requesting. And his testimony at the suppression hearing was that the statement that I cited at the beginning was he was about to tell him The only way under 80420 you have the right to a confidential consultation is if your attorney comes down in person. He stopped himself.
What does in the presence mean? I mean, in the presence can mean watching the defendant through a glass where you can't hear what's going on. I mean, that could be fine, and I think in the presence probably is a security thing where the legislature didn't want them to just go down the hall and use the payphone, and then maybe go out the front door rather than come back to the cell. But, I mean, in the presence in this situation seems to be a balancing of the security interest of the jail and the custody versus the right of the client or the defendant to talk to their attorney, and it could be done maybe without going to the Constitution if we construe in the presence in a certain way.
And it certainly could. It certainly could. But I would urge the court to consider the constitutional argument as well, because it has this provision that we're arguing does have additional language that is separate in this. I mean, it adds to it, and they intentionally added to it. Yes.
Let me play out that language, Mr. Rehkemper. The language, and I'm kind of paraphrasing, but it's there, that you're relying on. In cases involving the life or liberty of an individual, the accused shall have a right to have the assistance of counsel. That's essentially with leaving out the parts about the public trial and all those other things. That's what we've got here. And you're saying cases begins as soon as the individual's arrested.
That would be one way to look at it.
Well, that's your way, isn't it?
My argument in the brief is that it begins at the time implied consent's invoked, because that's the critical stage where the individual should be entitled to and needs the assistance of counsel.
All right. Because, I mean, whether it begins at the moment of arrest or at the moment of implied consent, I mean, you're talking about a whole lot of lawyers that are going to have to be on standby because people get arrested, implied consent gets invoked at any hour of the day. And if there's a right to counsel, it's not going to turn on whether the person can afford counsel or can wake someone up in the middle of the night, right? You're going to have you and your colleagues we're going to have a whole lot of lawyers just kind of on standby that'll come down to the police station to handle all these OWIs, won't we?
No.
Or tell me why I'm wrong.
I don't think you have to go that far. In fact, the Oregon Supreme Court addressed that very argument in Spencer. And the Oregon Supreme Court says, listen, we don't think necessarily that we're going to take Gideon that far where we have to actually provide somebody. Because of the peculiar nature of an OWI investigation, there are time-sensitive decisions that have to be made. Our argument would actually help speed the process along, because if I'm talking to somebody on the phone, if an attorney is talking to somebody on the phone, and we know the other side can hear or can listen or is recorded on one side, we can't effectively communicate with the individual to get the information we need to give them adequate and accurate advice. If you provide us that safeguard where I can ask this individual questions, they can respond in normal conversation, not yes or no's. Because trust me, that at 2 o'clock in the morning, that conversation gets really confusing one way or the other. If you give us the protection to be able to ask and get information from our clients, then we don't have to worry about, oh, I'm on my way down, or the attorney's on their way down. How long is it going to take for him to get here? 25, 45 minutes.
Counsel, isn't Mr. Hellstern, he isn't an attorney.
He is.
And in this case, he's on the phone with his attorney after implied consent is invoked, correct?
Correct.
And the statute says that phone call is in the presence of the officer.
Correct.
And so you're saying the legislature's passed a statute that's unconstitutional?
Yes.
Or you could construe it constitutionally by saying made in the presence means that the phone call was connected. You don't want to have an abuse of the phone call. It's made in the presence, and then you don't listen.
It depends on how you want to interpret the statute. If you interpret the statute that way, then it can all be squared together.
Haven't we already interpreted the statute to say that phone call itself is not private? It's the face-to-face conference that has to be private, alone, and confidential.
In Craney, that issue was brought up, and I don't remember specifically if the court actually addressed what in the presence of the arresting officer entailed, but they did say when the young lady said, "I killed my baby," in front of the officer, that was going to come in.
Let me ask this question. The Iowa Constitution, it does have the language you cite, cases involving liberty, for example. That could be a mental health commitment. It could be habeas corpus. Civil cases. It's kind of a civil Gideon. Fugitive slave, which you have cited, and I think there's no doubt that's what it was originally directed to. That was a motivating, because there's a lot of fugitive slave litigation in Iowa, as you know. So clearly, maybe the right to counsel in Iowa applies outside criminal prosecutions, but it still is limited, as has been pointed out, to a case. Make your best argument that there is a case here when there's been admittedly an arrest, no filing of charges yet, maybe a critical stage in the proceeding, but does that make it into a case?
It should, and it has to come down to the role that counsel may play and does play in that proceeding. In a lot of these other proceedings, meeting with counsel or having counsel at a later stage after, we'll say, the formal charges are filed, doesn't make a huge difference on the case in general.
I don't doubt, let me, I'm sorry to interrupt you, but I don't doubt, in my own mind at least, that this is a critical stage of the proceeding. I mean, once, if you decline a test, the subsequent trial on declining the test is going to be fairly meaningless, because you're already cooked. You decline the test, you can't revoke your declining the test, et cetera, et cetera. So in terms of whether or not this person, in a functional way, whether or not there's going to be possible liability attaching to his judgment, it's going to happen then and not later at trial. So I get all that, but I'm still working on the issue of, well, you still need to have a case. And is it your argument, I guess, that the case is a functional determination? A case exists when there's a focus and kind of rightness concerns. I'm struggling with your approach to the term, quote, case.
Well, when a person is arrested, the charge is nothing more than a formality. When after implied consent is invoked, they're already saying they have probable cause and they have a basis. So at that point in time, the actual charge is nothing more than a mere formality. It makes no difference in the determination. As Justice Brennan talked about in Kirby, there is no functional or there is no reasonable purpose to treat the filing of a preliminary complaint as the go time for when counsel is appropriate. You look at the general circumstances and the position that the individual is placed in to determine when counsel is appropriate and when counsel should be entitled.
But at least it provides a bright line for when counsel attaches, doesn't it?
It's a bright line that doesn't make sense. And in Iowa, we have a history of talking about things like substance over form and rights over mechanics. Just saying that that's a nice bright line. A bright line is a bright line, but if it doesn't make sense and doesn't square with the purpose of our Constitution and the history of our Constitution, then we shouldn't have a bright line just to have a bright line.
So he's changed the bright line in this case for any time there's implied consent, right to counsel attaches. Is that correct?
Correct.
We carve out an exception for implied consent and say that under those circumstances, then you have a right to counsel.
Because of and that's what Minnesota has done. That's what Oregon has done. Because of the peculiar nature of implied consent. Implied consent is a different animal, and implied consent, it puts a person in a situation like even the case before this argument has demonstrated, where there is a function of counsel at that point in time. And I'm not saying that you have to...
The counsel, the Minnesota state constitution that the Freedmen Court relied on is worded differently, isn't it?
I don't believe that the constitutional provision was, and I'd have to double check, but if it was, it was. But our Constitution is worded differently as well.
Well, if it was, then that case may not do anything for your position. But you've done this area of the law for a while. Isn't it the working understanding of the criminal defense bar that the cop may be listening on that phone call, and that's why if you want a private conversation, you hustle down to the station?
It is, and that's the problem. And that's why I'm asking to change that, because I can't effectively communicate. We've dealt with it. We've had to get by with the rules that we have, but it doesn't make it correct because it's gone on for so long and we haven't raised it. I see my time is up. Thank you.
Thank you as well, Mr. Rehkemper. Ms. Hall.
May it please the Court. The State first notes with respect to the 80420 issue that there is a difference of approximately 8 minutes between the time notations Officer Dyer used and the times, and this is used in his officer's narrative and the implied consent form, and the time stamps on the jail video audio recording. The State focuses on the times that the officer has noted and then adjusts the times, adds on, they're actually 8 minutes later, adds on 8 minutes to the video times when you're trying to determine at what time what was said or not said. We believe the purpose of 80420 is to provide a newly arrested person with a reasonable opportunity to make contact with an attorney or friend. This limited statutory right applies to all arrestees and not just OWI arrestees. This Court and our Court of Appeals have noted that such persons are not, at this point, guaranteed actual contact with or the receipt of legal advice from attorneys or others, nor are they, in the implied consent setting, guaranteed a full 2 hours to make contact by phone or to wait for the arrival of a contact person at the place of custody. The State would ask the Court to find there was no violation of 804.20 because its purpose was served in this case. After the officer invoked implied consent, a defendant attempted to contact a number of attorneys using his cell phone over a 46-minute period before reaching Ms. Keeler, an attorney friend who practices criminal law. Defendant spoke to her for 13 minutes after the officer denied his request for privacy on the phone, during which time the officer did leave the room for 45 seconds. We'd like to point out that the jail recording shows that while the defendant was still speaking to Ms. Keeler, the officer advised him that he needed defendant's answer soon. Right after the defendant had hung up, the officer told him he was out of time. After 11 minutes of further conversation took place between Dyer and Hellstern, the officer demanded his answer. The breath test was ultimately completed approximately 9 minutes before the expiration of the 2-hour period. The State does not interpret this Court's decision in State v. Walker to place a duty on the officer to advise an OWI arrestee who is actually speaking to an attorney on the phone of the option of meeting privately with that attorney at the place of custody or with another attorney.
Sure, he's not entitled to confidentiality right on the phone, and here's why. This is an unusual procedural posture, I think, in the following sense. When the decision is made on informed consent, the game, if you will, and I don't mean to disparage it, but the result is going to happen at the police station. If the defendant refuses, a lawyer the next day is not going to help relieve that person of criminal liability. The critical stage of the process is making the decision whether or not to take the test. Now, admittedly, that's prior to kind of the filing of a formal charge, as we've discussed. But this is the pressure point, not sometime later. And so why shouldn't we attempt to interpret the statutes or at least try to allow these potential defendants at least to get good legal advice when it matters, because it's not going to matter the next day. I think you understand the thrust of my question, and why don't you respond, please?
Well, Your Honor, our point is that he was actually speaking to an attorney on the phone, and the statute says that that phone call is not private. But not confidentially. I mean,
the speaking on the phone with taping and with people listening, if a right to counsel attached there, that wouldn't be satisfactory. I think it's pretty clear. It may be disagree with that, but I think it's clear that if there's a right to counsel, it implies confidentiality. But don't you agree with me? I think, frankly, you have to agree with me on part of it, and that is the key part of this whole transaction is right then in the station when informed consent is invoked. And that's the critical point, not the trial. The trial is formality. A trial later, after indictment, so forth and so on, if one declines the test, the ball game is pretty much over. Don't we want to have assistance of counsel at that critical juncture?
And, Your Honor, our point is he did have such person at the place of custody.
I mean, Justice Wiggins raises a really good question, but would one possible answer be you don't really...
So we have a line of cases where we held that the officer had a duty to
make a phone call, and this court has found and that so that's our argument. In addition,
so are you hanging your hat on the fact that he was talking to an attorney? If he had just said, if I call an attorney, will I be able to make a private call? And the officer has said no, would the case have a different outcome?
I don't think so. The officer is relying on the statute, which says the phone call is made in the presence of the person having custody. Our other argument is that, as a practical matter, if the officer had mentioned...
Question. Where does the statute say in the presence of the officer mean they could record it?
It mean that you recorded?
Yeah. Where does the statute allow them to record the conversation at one side of the conversation when it says in the presence? Presence doesn't mean that you could record the conversation, does it?
Well, that was the issue at Walker, was when the attorney was at the place of custody, whether or not that meeting had to be private without video or audio surveillance. That's not the issue that's raised in this case. We also want to point out that had the officer fully advised him about the private meeting option, he could have also indicated that he believed there was insufficient time for the attorney to make it to the jail to still administer the test within the 2-hour period. Moving on to the constitutional claim, the defendant essentially seeks to have the right to counsel triggered at the evidence gathering or investigation stage by law enforcement and fails to address how such a holding could be limited to only OWI arrestee attorney phone calls and not other arrestees.
Oh, no, I'll limit it. And that is that, once again, when you have this informed consent procedure, the critical stage of the process, unlike lots of other arrests, the critical stage of the process is right that night. If you get arrested for, I'll just say theft or some other crime and you get carted off to jail, and there's no interrogation, you're being held in custody, your lawyer gets there the next day. The only thing that's happened to the defendant is they've spent the night in jail or whatever, and counsel has an opportunity then to effectively defend. But this is a little bit unusual. Here, the critical evidence gathering stage, if you will, as I keep on saying, the whole ball game or whatever, and I'm sorry to be colloquial about it, but this is really unusual. The critical stage of the process here occurs at the jail. So I understand what you say, all arrests, we can't have that, and I'll, for purpose of argument, kind of concede that, but this is kind of unique. It's what Justice Brennan was complaining about in Kirby in the connection with the lineup, right?
But we don't have a lineup type of situation here, and I would point out that 30 years ago in State v. Craney, which was outside the OWI context, this court held that the attorney phone call during which the defendant said, "I killed the baby," was not intended to be a private phone call, and that did not violate the Constitution.
But that was a different situation. That wasn't time sensitive. I mean, the law is based on the facts, and those facts were far from what happened here.
Up to this point, the court has consistently followed the majority of state and federal courts.
Do you see a difference between the two?
I don't really see a difference between the two. The defendant in Craney was sitting there waiting for booking. She makes a phone call to her attorney, and she's not entitled to privacy on that phone call, and the court wasn't bothered by that. This court has consistently followed the majority of state and federal courts in holding that the Sixth Amendment right to counsel attaches at the stage where the government's role shifts from investigation to prosecution. In Walker, in the OWI context, the court reaffirmed that the initial attorney phone call is not private, despite the fact that a decision on chemical testing carries significant consequences for criminal liability and driving privileges.
But the constitutional issue wasn't served up in Walker, was it?
It was a Sixth Amendment issue.
But the state constitutional issue that has been raised by counsel wasn't served up in that case, I don't think, was it?
No, not the Iowa constitutional issue. The court in Walker specifically noted that attorneys generally advise their clients to give only yes or no answers on the phone, and further noted officers must observe the suspect for 15 minutes before administering a chemical test. I see my time is up. The state would request the court affirm the defendant's conviction.
Thank you, Ms. Hall. Rebuttal argument?
Whether it's in the 804-20 context or in the new context as we're framing it, Article 1, Section 8, this court has been consistent in declining and in denying form over substance arguments. The state has repeatedly, since Viator came out in the 70s, attempted to articulate that, well, this request was not sufficient enough. Well, this act by the defendant was not sufficient enough. With this case, with this fact pattern, the court has an opportunity to clear up a lot of the murk, a lot of the mud that has been created by not starting with a bright line rule under 804.
Counsel, does it make a difference that Mr. Hellstern was on the phone with his lawyer for some 13 minutes, as opposed to in the other cases, Garrity, Dodano, Lukens, they hadn't talked to a lawyer? Does that matter when the issue is whether the officer has a duty to explain more? Why isn't it up to the defense lawyer to do the advising?
Because if you start down that road, it's going to raise more questions than it's going to solve. Suddenly it's going to go to the fact of, well, that was my family law lawyer, that was my business lawyer who has no knowledge that 804-20 even exists. It's going to be, well, it was my second year in law school son. It's going to be law enforcement.
In effect, are you saying the officer becomes the defense lawyer?
Under 804-20, the statute specifically imposes the duty on the officer or person having custody, nobody else. So if you're looking at the 804-20, that's a statutory requirement that is placed specifically on the officer, not the attorney, not the individual, because there is no, when it comes to Miranda, we don't say you don't have to Mirandize somebody because they're an attorney or because they have law enforcement background. And to follow up on your other question about the Minnesota Constitution, the Minnesota Constitution language mimics the Sixth Amendment to the United States Constitution as it pertains to right to counsel. And so if you compare that to Iowa's constitutional provisions, that's much more of an argument to say that it should be applied in a more expansive role than it otherwise would. If Minnesota would do it under a similar provision.
I guess I want to talk a little bit about that. When you talk about, I think you were talking about the Friedman case and then also the Campbell case in Minnesota, they talk about the concept of a limited nature of the right to counsel in this exact context. And that's what they're relying upon. And they say it's fine to have this limited nature of the right to counsel. Then when you get into Spencer, you're also talking about that the arrestee has a limited right to counsel under their state statute. And then under Vermont, the same thing. You have a limited right to counsel granted under the Sixth Amendment at doing the same critical stage analysis. And so everyone else is doing the same thing we're doing here, and the analysis is the same.
No. I agree with the limitation on the right to counsel. Under the peculiar circumstances of implied consent, time is of the essence. However, confidentiality of that conversation with counsel must apply. The other restrictions I don't believe are unreasonable to say that it has to be provided or it has to be exercised in a reasonable time within a reasonable opportunity. But to say that you can have this counsel but the officer can sit there and listen.
So just so I'm clear, you're agreeing then that there is everyone recognizes just this limited right to counsel. Yours objection is on the whole issue of confidentiality then.
The confidentiality is my entire objection, and I put that in my brief. We can apply the case law that we have to reasonableness under 80420 and the Viator and Garrity and Hicks and all of those, but still afford the individual the confidentiality with counsel, because that's the most important part.
But to follow up on what Justice Zager was asking, you agree that in Minnesota, which you're relying on, the officer gets to be in the presence when the phone call is made. That's the Campbell case, right?
That I'm not 100% certain. I would have to double check, and I meant to before coming down and arguing it. But in Oregon says no, you can't record it, you can't stand by, and that would be the confidentiality, the privacy application that I'm asking the court to apply is give them at least allow them to talk with counsel without having to worry about waiving attorney-client privilege, without having to worry about what they're being used against them at that critical stage in the proceeding. Thank you for your time.
Thank you as well, Mr. Rehkemper. All right, we'll take a 10-minute break at this time, and we'll reconvene at 10:30. And just for the benefit of the students, we'll retire to our conference room later this afternoon, or later this morning, actually, and begin discussing these cases and begin the process of making a final resolution on the two cases that you've heard this morning. And if you're interested in following along, every Thursday we'll publish on our website a list of cases expected to be filed on Friday. We file all of our opinions on Friday during our term of court. And so if you're interested in following along, in a couple of months you can be checking that expected list on Thursday and then read the final result through a written opinion that will be filed by the court. So thank you again for coming into our courtroom and listening to our cases and celebrating our Constitution. We'll be in recess for 10 minutes.